And it looks like Mr. Pelzer and Mr. Levy are both in the courtroom. So we are prepared to go forward if you're all set. Mr. Pelzer.
Good morning, Your Honor. May it please the court. My name is Jack Pelzer. I'm here today representing Patty Fortune and Jeremy Dahman. I'd like to reserve 5 minutes for rebuttal, if I may.
Very good.
There's a single question before the court today, and that is whether the mere pendency of an insurance appraisal constitutes a cure of a civil remedy notice as a matter of law. And the answer to that question, based on the case law and the statutory interpretation, is clearly no. Before we get into that, though, there are two concepts that apparently confuse the trial court and the insurer in this case that need to be made clear and kept clear. The first is that Section 624.155 creates a statutory remedy based on statutory duties that is in addition to and independent of the contractual duties and remedies that are provided under the policy. The trial court clearly confused the statutory remedies of the civil remedy notice and the ultimate bad faith action with the contractual duties to appraise and pay the claim once the appraisal came in.
It seems the issue is whether an appraisal, which is a condition precedent to the lawsuit, is a condition precedent to any liability under the statutory notice. I mean, is that what it basically comes down to?
Essentially, yes, Your Honor, and the Landers Court answers that question for us. That's where, in that case, the insurer made precisely that argument, that because appraisal is a condition precedent to payment under the policy, it's also a condition precedent to liability under 624.155 and the need to comply with the CRN process. And the court in Landers said no.
Was the policy language the same in Landers? Was the policy language the equivalent to the language in this case?
We believe it's equivalent, Your Honor. The language is not quoted in that opinion, so it's not possible to compare it line by line. But an appraisal clause in most of these first party or in these homeowners insurance policies are roughly the same. Okay. And they do provide that if one party or the other, at their option, chooses appraisal, then completion of the appraisal is a condition precedent of payment. But
that doesn't tie it to the civil remedies notice or anything else. Not
at all. Not at all. The two really do not interact. In fact, the Vest Court, the Supreme Court in Vest, was the first comment on this issue. Expressly stated that, notwithstanding the fact that the exact amount of damages had not yet been determined, the insurer must still evaluate a claim based on the proof of loss and its own expertise in advance of the determination of the amount of damages. So going through the CRN process but
they didn't even come close to the analyst appraisal that you had obtained.
That's correct, Your Honor.
The amount in controversy was a 10-to-1 difference.
That more than 10-to-1, Your Honor. The amount the insurer proposed to pay was less than $4,000. The appraisal came out at $114,000, and both of those numbers were
the
down.
Public adjuster.
Right. Well, no, that was the appraisal. Our public adjuster was over $200,000.
Okay.
So when the public adjuster and the referee, who was chosen by both adjusters, both appraisers, I should say, our appraiser and the referee agreed on a $114,000 number, which was already net of the deductible. Similarly, this court in the Hunt case expressly said that an insurer's response to a CRN is not dependent on the determination of damages, whether it be by arbitration, by appraisal, or by judgment. The insurer still must evaluate the claim. And Of course, the Hunt case also has.
I just have one question. The court made a finding in the order, and it said the defendant cured the civil remedy notice by its invocation of the appraisal process.
Well, that's
And as a matter of
chronologically.
law, that cured the problem. Did the court cite any authority for that? There's nothing in the order.
No, Your Honor, and in fact, it's contrary to Landers, and it's also contrary to the calendar, because in this
Those cases
case,
were argued to the trial court.
yes, they were, Your Honor. The Landers, Hunt, and Best cases were
Did she
all
cite
argued.
the federal case that the other side cites?
She apparently was relied upon and persuaded by the misinterpretation, I would say, of the 316 case.
Self-imposed, let's say, or
That's right.
brought into the argument, that letter there.
Right, and that 316 case, or the misinterpretation, I should say, of the 316 case has been cleared up by two other federal district courts in the Foxfire and the Royal Marco case. And they both stand for the proposition that even 316 does not stand for the proposition that invocation of appraisal cures a civil remedy notice. And of course, we have the Coral Reef case also from the federal district court here in Florida, that the CRN process and the appraisal process are separate and distinct processes. That's what they say, the first principle that we have to keep clear in this entire discussion. So the insurer in a CRN case cannot end run the statutory procedure and its statutory duties simply by invoking the contractual remedy of appraisal. The two are not dependent upon one another at all. In addition to the case law.
The appraisal process, as I understand the appraisal process, that is not designed to eliminate an insurer's obligation to independently, using its expertise, evaluate a claim that's been submitted and either deny it or pay what it determines is an appropriate amount. Is that correct?
That's exactly right, Your Honor. The appraisal process is just another alternative to the court system. It's just like arbitration in that sense. And that's the reason why we even treat appraisal and compulsion of appraisal as though it was compulsion of arbitration, because it's just another alternative dispute resolution mechanism. And just like you don't have to go to trial and get a judgment from a court determining the amount of damages before you can go through the CRN process, you also don't have to go through the appraisal process. They are independent of one another. And this is also apparent just from reading the language of the statute itself. There's absolutely no language in 624.155, subsection 3C. It was D at the time, it's been relettered to C now. But there's absolutely no language in the statute that says that filing a CRN notice stays the 60-day safe harbor period, which is essentially what the insurer is arguing here. We can't add those words to the statute. That would be a violation of the text of the statute and violation of rules of statutory construction going back centuries. Now, the insurer in this case attempts to use the disjunctive language of subsection 3C, where it says the insurer may either make payment of the damages or correct the statutory violation, and somehow suggests that invocation of appraisal constitutes a correction of a statutory violation or correction of the situation.
To accept the insurer's argument, then it seems like what it basically is, if we are in disagreement as to the amount that's due or as to liability under the policy, then that circumstance can be corrected by invocation of appraisal. I mean, is that basically how they came at this argument?
That is their argument, Your Honor. But this disjunctive clause is simply to accommodate the fact that 624.155 has both non-payment or monetary type breaches as well as statutory procedure breaches that can give rise to a bad faith claim. In order to correct a monetary breach or a failure to pay, then the pay damages side of the disjunction applies. If it's some other kind of practice or procedure, There are 6 separate statutory violations that this could possibly be, as well as a failure to properly put notations on checks. If you have that kind of a practice violation, then you can cure it by implementing procedures. And that's why we have the disjunction here, because there are potential non-monetary defaults or non-monetary statutory violations by an insurer under the bad faith statute. And that is where the second half of this disjunction comes into place. If we allowed the cure of a monetary default, a failure to pay default, to be addressed in the second half of the disjunction, then the first half of the disjunction has no role to play in the statute at all anymore. And you're essentially reading that language out of the statute, which again is a violation of cardinal rules of statutory construction. Plus, the payment of damages side of the disjunction is the more specific one, applying to the failure to pay damages breaches of statutory duties. And so it's appropriate to apply that side of the disjunction to those kinds of breaches. So for all those reasons, this argument based on simply the use of the word "or" in that subsection fails based on statutory construction grounds. There's another statutory construction argument based on the 2019 amendment to the statute, which relettered the section and added subsection F. That 2019 amendment, which went into effect last July, provides a 60-day standstill against filing CRNs once an appraisal has been invoked. If the insurer's interpretation of subsection C is correct, then this new subsection F that went into effect in July has absolutely no meaning and absolutely no purpose. And so for that reason, you should reject the insurer's interpretation of subsection C. And in effect, really, the insurer's argument eliminates the entire bad faith statute, the entire CRN process for any case involving any insurance policy involving appraisal, because all the insurance company has to do is invoke appraisal, and that operates as a cure of everything. And so whatever bad faith actions the insurer took, even invoking appraisal in bad faith for the sake of putting additional expense and additional delay on the insureds when the insureds should have been paid already if the claim had been properly handled, is itself an additional burden that the insurer is forcing on the insured. If there are no further questions, I just would point out, Ms. Fortune and Mr. Doman have followed all the statutory procedures of section 624.155. They've met all the conditions precedent. They are now entitled to their day in court to prove to a jury that the insurer in this case did in fact act in bad faith. So we ask you to reverse and remand for further proceedings, and I'll reserve my remaining time for rebuttal.
Very good. Thank you, Mr. Pelzer. Mr. Levy. Mr. Levy, you're up. You don't forget to, there you go.
Good morning, Your Honors. May it please the court, Jay Levy on behalf of First Protective Insurance Company. Your Honors, in the 316 case, which was the case that was relied upon before the trial court, the case, the judge stated, quote, "If I were to follow plaintiff's line of reasoning in this case, I would be in effect saying that an insurance company is acting in bad faith if it doesn't pay whatever a plaintiff demands when the plaintiff files a civil remedy notice. This is not the law."
Well, is that what the judge?
That's actually not a correct analysis, is it?
Yeah, I was going to disagree with that, but you go.
That seems to me to be putting the cart before the horse, because the issue is, has the insurance company fairly and properly evaluated the claim? It could be that the $10,000 evaluation, and then I think there were some deductibles and whatnot that results in a $3,000 payment. It's possible that that was done in good faith, but we don't reach that question, right?
Well, I think the issue here is the tension, and I think Mr. Pelzer's just on the other side of the tension here, but the issue here is the tension between appraisal and the bad faith statute. And this case is driven... The
appraisal is a part of the policy in relation to a condition before suit or before collections, whatever the policy language is. But how does appraisal in and of itself establish good faith or bad faith on the part of the insurance company? Isn't the insurance company supposed to exercise its due diligence to determine, is their demand reasonable? Is it unreasonable? What's the value of this loss? And are we liable for it?
I think in this particular case, Your Honor, given the facts of what happened here and the chronology, this was a loss that occurred on September 10th of 2017. 117 days later, after we had determined that the loss was $10,000 and we had received a PA's estimate that Mr. Pelzer says was in excess of $200,000, the company took the position that the gap was great, it would never be resolved, and the appropriate way to do this would be to go to appraisal.
All of which is fair under the policy language. But how does invocation of appraisal determine as a matter of law that your client's $10,000 offer was an appropriate, reasonable offer under the circumstances?
Because the appraisal is the appraisal is a contractually agreed upon way to handle these kind of situations.
And what that does is it passes the determination to someone else. But the statutory language says basically an insurance company has to do its own evaluation in an effort to avoid further proceedings. Isn't that correct?
It is correct, but that evaluation was initially done. And that, in other words, this $3,000 figure was not picked out of the air. It was
and our resolution of this case, or the trial court's resolution of the appraisal issue, doesn't say that your client acted in bad faith. It's just a question of, does the appraisal stop everything, or the appraisal now has resulted in a resolution of the damages claim, but whether your client acted appropriately or not is subject to additional proceedings, may be resolvable by summary judgment, may be resolvable by trial. But I'm honestly having a hard time with the idea that an insurance company, not necessarily in this case, but in any case, an insurance company can say, we don't think we're liable, we're not doing anything further, sue us. Suit is filed and then appraisal is invoked. How does the appraisal fix the demand that the statute provides under the CRN?
If you go back to Landers, the case says in Landers, it says the purpose of the bad faith statute is to discourage insurers is to make sure that the insurance take timely action on claims. The chronology here with the invocation of appraisal was exactly that. This was something that was not ignored. If you look at all these timelines in Landers, for example, the appraisal took place 3 years after the incident.
Well, let's do this step by step. Landers rejected the argument that the CRN can't be effective as some sort of condition precedent to filing the suit, right?
Landers held that that a CRN is
it stands alone.
The pendency of an appraisal has nothing to do with the CRN. It can be filed.
So there's a statutory CRN process, and the parties obviously are at some disagreement. And the statute then says, if within 60 days of the filing of the notice, damages are paid or circumstances giving rise to the violation are corrected. So is it your position that an insurance company who may be acting in bad faith has cured that bad faith by virtue of an appraisal process?
If the appraisal process is invoked quickly, like it was in this case, I am not suggesting that you should sit around for years and argue for an appraisal. One of the key facts to me, Judge Silberman.
But it has to be invoked. To follow your logic, the appraisal process would have to be invoked within 60 days of the CRN.
But that's the key here. The appraisal process in this case was invoked before the CRN.
Okay, so tell me, how does an invocation of an appraisal process cure a question or a determination or a fact as to whether the insurance company acted in bad faith?
It seems to me, well, specifically, if the contractual remedy is provided for appraisal to determine what the amount of the loss is, and the carrier determines that there is a difference that needs to be adjudicated, it seems to me that if you quickly invoke the appraisal process, the contractually agreed upon remedy, as all the cases seem to indicate, that to bridge this rather large gap, that is the appropriate way. And I disagree with something Mr. Pelzer said with regard to the amendment. And I recognize that the amendment is not applicable in this case, but it does indicate the legislature's intent that the bad faith aspect of this defer to appraisal. And that the appraisal—
we don't have to, obviously, you've already acknowledged we don't have to get to that because that's not relevant to our decision today.
I understand, but it does.
So again, oftentimes we have to make a decision that will impact other cases. So if we agree with your proposition, are we basically accepting the idea that an insurance company actually doesn't have to do any evaluation if it so chooses? It waits to see what the insured does. And then if the insured files a CRN, they say, okay, let's invoke the appraisal process. We will defer to that.
No, I think I disagree with your hypothetical in this regard, Your Honor. I think that the hypothetical must track the facts of this case. That is that the insurance company had somebody go out, do an estimate, relied on that estimate, then the public adjuster goes out and does an estimate. In other words, if it was just as your hypothetical, as I understood it, was that the public adjuster went out, did an estimate, and we disagreed and invoked appraisal, I would not agree that that would be appropriate. But here, when both sides have done an estimate, that makes this a different.
But that goes to the question of good faith versus bad faith. It doesn't go to the question of whether the appraisal cures the bad faith.
But the judge found that by invoking appraisal, there was no bad faith in this case. That's my understanding of what
the judge found as a matter of law. So that rules out any factual dispute.
Well, the judge found that this is a sparse record. That's probably
okay.
That's probably an understatement.
But your position, tell me if I'm wrong, your position is, or at least first protected is, we have a policy, the language says, you can't bring suit against us unless you've complied with the policy.
I lost you, Your Honor.
Okay, I'll repeat the question because my short-term memory is about to go. The policy
Have I lost
says,
you all?
I'm
my
still
goodness.
talking. You're frozen.
Mr. Levy, if you can hear me, you are frozen because I can hear.
Now you're back. You've thought out.
Good. I just had ordinary. I'm sorry, Your Honor.
So I'll get to my question. I hope we get an extra minute because you were frozen for a while. The policy language in your client's estimation says you can't bring suit against us unless you've complied with the policy.
Correct.
So if someone agrees to the appraisal, how have they not complied with the policy by bringing a CRN action? They've complied with the policy, they agreed to the appraisal. You couldn't see eye to eye, but they didn't violate the spirit of or the letter of the policy. Help me out there. Back to frozen land. Okay.
Can you
hear your thought.
Mr. Levy, were you able to hear Judge Valente's question?
I did hear it, but I heard part of it. Judge, I apologize. Could you repeat it for me?
Yeah, but then I'll probably forget it. So the policy language provides you can't bring suit against us unless you comply with the policy. Am I right so far on that? And,
correct.
And your contention is by bringing a civil remedy notice, you haven't complied with the policy, but the policy doesn't refer to the CRN. It refers to an appraisal. Your client has a right to an appraisal, and they agreed. You got a right to an appraisal. So how have they not complied with the policy in this instance?
Well, I think the argument that I'm advancing is that if we invoke our appraisal rights to resolve a disputed issue of damages, which is what the CRN goes to, that's the compliance that satisfies and ends the bad faith. I would agree with a couple of hypotheticals here, and your honors are frozen, so I'm just hoping you can hear me.
We hear you fine.
Great. Okay. I think the difference here is the basic facts. If we had sat on this, okay, and invoked appraisal after the CRN, I think that would be a different ballgame because that would indicate some delay on the part of my client. But there was no delay here. We looked at their estimate, we saw what the difference was, and we immediately demanded appraisal to resolve this issue, which would have satisfied the entire matter. If we had demanded appraisal and not gone to appraisal for 3 years, like occurred in the Landers case and in some of these other cases that are cited, but both the cases that counsel cited in his brief that talk about 316, the Foxhaven case and the Royal Marco case, both of those cases hold where the insurer acts with reasonable promptness to resolve the claim. That's how they interpret 316 and hold under those circumstances, there's no bad faith. So
Mr. Levy, so again, I want to make sure that we're on the same page on this. Your position is if the appraisal process is timely invoked, there cannot be bad faith on the part of the insurance company.
I would prefer to use the word expeditiously invoked.
I would use the word you want. If it's invoked within a timely fashion or an expeditious fashion, anything that the insurance company did or failed to do is before that point is irrelevant. There can be no bad faith claim.
As long as appraisal is invoked before the CRN.
All right, well, that's the issue on appeal.
So that's where we are. Again, Judge Vellante, this case evidences what goes on and the tension that exists between appraisal and the bad faith statute.
You're not opposed to us writing. You want us to write to affirm, but it sounds like a written opinion is necessary.
Well, you know, Your Honors, how you write your decisions and what you do is
well, obviously a PCA is your best friend, but what I'm saying is your argument is there's a lot of confusion, there's a lot of tension. Regardless of the outcome, it sounds like an opinion would be advisable.
I can't disagree with that, Judge, but let me say one other thing. Counsel said that he wants this case to go to trial, okay? And it may, in fact, if you reverse, go to trial. But I don't think we should be foreclosed on a better developed record, perhaps, from advancing the argument again in a motion for summary judgment. Because this case,
ultimately, it's the issue of bad faith versus good faith is a question of fact.
Right.
What has happened here is the trial court has said there's no issue of fact to be determined because invocation of the appraisal process in the manner it happened in this case alleviates any possible liability for bad faith.
Based solely on the pleadings that were filed and the exhibits there too. That's my point. There were no affidavits or anything filed along those lines. So this case went solely on the complaint and what was filed along with it. So I think the court understands my position. On behalf of First Protective, we would respectfully request that you affirm. And I do thank the opportunity to appear before the court. And I thank you for allowing us to do this by video so that we don't endanger anyone's health. Thank you, Your Honors.
Very good. Thank you, Mr. Levy. And yeah, the use of video technology has been terrific for this current situation, and we will see how long it goes. So thank you. And Mr. Pelzer, you're up.
Thank you, Your Honor. Two brief points on rebuttal. First is the counsel's statement of his position, his client's position in response to Judge Silberman's question would effectively require rewriting section 624.155, which is not what this court can or should do. It imposes a bunch of amorphous conditions and tests that simply aren't found anywhere in the language of the statute. Secondly, with respect to the 2019 amendment, my colleague is correct. This was an effort by the legislature to give insurance companies a break, give them the 60-day standstill on filing CRNs once appraisal has been invoked. But that entire break that was cut for insurance companies makes no sense if the insurer's interpretation of subsection 3C is correct, because there would be no reason for the standstill because, in fact, the CRN would have been cured by the mere invocation of the appraisal. And even under the 2019 amendment, after that 60-day standstill is expired, the insured can still file a CRN and go through the whole process and get ready to file a bad faith claim, even though appraisal has already been invoked. So the interpretation of the statute simply doesn't hold up under normal rules of statutory construction. Again, we ask that you reverse and remand this case for further proceedings.
Very good. Thank you both. And you may now leave the meeting. And we will then call the final case on today's docket, which is Ruiz versus Peacock.